Good morning and welcome to Brodie's Procurement in Construction seminar. I'm David Arnott and I will be your chair for this morning's session. Turning to our speakers, we have two of Brodie's procurement specialists with us this morning, Charles Livingstone, a partner in Brodie's, and one of our legal directors, Jamie Dunne. Charles and Jamie have delivered previous sessions on the Procurement Act before it came into force. Now that the Act is in fact in force, they're going to focus on points of interest that are most relevant to the construction sector. And with that, I will pass straight over to Charles and Jamie.
Thanks very much, David. Yeah, here's what we're going to cover today. We'll give you a little bit of an introduction on the Procurement Act. As David said, we're not going to spend as much time on the sort of the commencement process and transition and things like that as we did in the November webinar that we did, which a recording of which should still be available. If you can't find it, just get in touch and we can send that to you. That was a little bit more generic. It was supplier focused, but not construction focused. So there are some things in there that wouldn't be relevant for this audience. There might be bits and pieces that you would find of interest, but we're really going to drill down on what we think are the key points for construction businesses to understand when dealing with the public sector. So our introduction will cover the Act. We'll speak about the scope of the Act, what sort of authorities are covered by it, and we're not going to spend a lot of time on the distinction, but the main thing to understand about scope is that it doesn't apply to devolved Scottish authorities. They're still under the old regulations. We'll then speak about some of the key changes, again, just focusing on those things that we think will be of most interest to construction, and indeed things that are as much about new contract management requirements as they are about contracts being awarded, and we'll then say a little bit about how the litigation picture is different under the Act, and if you're going to challenge a decision that you're not happy about, you'll need to operate that slightly differently from how you did under the regulations. So on our introductory slide, you can see references to the regime. So there's a Procurement Act 2023, which came into force on the 24th of February of this year, and applies to procurements commencing from that date. So there will still be some procurements that are running that commence prior to that, and those are still governed by the old public contracts regulations or utilities contracts regulations, whatever it may be. But over time, we'll get to the point where all procurements carried out by the authorities that are within scope are covered by the 2023 Act. The Procurement Regulations 2024 then contain a lot of detail, but it's mostly detail about what needs to go into the various notices. So detailed provision on transparency, and we'll spend a little bit of time on that because there are some quite key changes to how much transparency there needs to be under the new regime. And these pieces of legislation are accompanied by 48 guidance documents, so there's a lot of information out there. That's all stuff that was obviously published prior to the Act coming into force. It has been in force for 2 months as of today. So there are, bits and pieces have been coming our way in relation to that. Been doing more work on the authority side for obvious reasons, because the authorities needed to get ready for this coming into effect and update their templates and that sort of thing. So more so than we have on the bidder side, although we are seeing bits and pieces on the bidder side. So what would actually be useful, David mentioned putting questions in the Q&A, but we'd also be interested in understanding if anybody's had any experiences with procurements being operated under the Act or contracts being managed under the Act. Early days for that, but any of the sort of thing that we're talking about, if you've had experience of how that's operating under the Act and you think you've got a story that would be of interest to the audience, then feel free to pop that in the Q&A as well, and we can maybe share those at the end. Very much a learning curve for everybody at the moment. So yeah, just to finish this slide, so the Act replaces the public contracts regulations, concession contracts regulations, and utilities contracts regulations, as well as the defence and security public contracts regulations. And these are all the rest of UK, if we can call them that, regulations. They're not the Scottish versions, as Jamie will explain on the next slide.
Thanks, Charles. So, yeah, speaking of learning curves, those of you that operate across the UK are going to have or do now have a more complex landscape that you're operating in. So, where you're looking at contracting authorities outside Scotland, so a UK public body buying in England, Wales, Northern Ireland, um, or a local authority or any other body buying outside Scotland, then we've got the obviously Procurement Act, the procurement regulations that Charles mentions, and then any litigation following on from those will be in the relevant court in England and Wales or Northern Ireland. But where you've got a UK public body purchasing in something in Scotland, whether that is a sort of big state utility or it is a UK government body or a UK Quango, the Ministry of Defence, whatever it might be, then notwithstanding that they are buying in Scotland, something that is going to be in Scotland, something that's getting built in Scotland, it is still the Procurement Act and the procurement regulations that will apply, albeit the perhaps new change is that it's the Court of Session that any litigation will be in. It's the Court of Session that will be interpreting and applying that legislation, presumably consistently with the rest of the UK, but who knows? And then the complexity is that where the public sector buyer is a devolved Scottish contracting authority or utility in Scotland, then it will continue to be the Scottish procurement rules, those public contracts, utilities contracts, etc., regulations that you all know and love that will continue to apply alongside the Procurement Act, the Procurement Reform Act, and the Procurement Scotland regulations, which have been in force for almost 10 years now. And then litigation will continue to be in the Court of Session or indeed the Sheriff Court if relevant to value. So what do the changes then look like? We said we would sort of emphasize some of the key ones. Well, a lot of procurement litigation has been around the procurement principles, a requirement to comply with duties of transparency, equal treatment, non-discrimination, and proportionality. Those will all continue to be freestanding duties under the continuing regulations in Scotland, but where the Procurement Act applies, those are replaced with these woolier procurement objectives. And the rule on these is that the contracting authority has to have regard to the importance of them, which is obviously not quite the same as a duty to comply with them as such. Another thing that they have to have regards to is the national procurement policy statement, or indeed, depending on where the buyer is in the UK, the national procurement policy statement issued by the Welsh ministers or the Northern Irish executive in place of the one issued by the UK government. So there will be a lot of stress currently for contracting authorities is how they have regard to those statements and how they go about putting that into practice in their tenders. There's now a duty on contracting authorities to proactively consider breaking a contract into lots. The idea behind this, and it ties in with the National Procurement Policy Statement, is a duty to try and make things more accessible to small and medium-sized enterprises. So they should be proactively trying to break things down into smaller contracts to make it easier for smaller contractors to participate in competition for those contracts. The rule to the contract had to go to the most economically advantageous tender is replaced by a rule that has to go to the most advantageous tender. That legally, technically means absolutely nothing at all other than the removal of one word. But the idea behind it is to emphasize and encourage contracting authority buyers to look more broadly than just a pure cost benefit on the contract itself and think about how the contract could have a broader social impact and benefit. We go from 6 competitive tendering procedures down to 2, an open one, which just looks like the old open one, and a competitive flexible one, which looks like the old restricted or indeed negotiated, depending on how the contracting authority chooses to run it. Conditions of participation replace selection criteria, but that's primarily really a change of name. It's the same sort of qualification rules to get into a procurement in the first place that you will be used to, broadly speaking. We have a new idea of an open framework. So the old frameworks continue to exist, but we now have something called an open framework where it can be reopened to new members in a new competition part way through the life of the framework. So we've not necessarily seen a lot of appetite to start those yet. I think a lot of contracting authorities are nervous about using them, but we may see that come on in due course. And then there are specific rules for what are called regulated below threshold contracts. There's obviously this idea that below threshold, the rules are less strict, and contracting authorities can do anything they like, but that's not quite true under the Procurement Act anymore, where you're looking at what's called a regulated below threshold contract. So broadly speaking, a works contract, for example, that's between around £220,000 in value and £5.3 million in value, there are specific rules that require that to be more broadly competed than the ones that are higher than the threshold. So actually a requirement not to, for example, apply qualification criteria. So some more competition actually perhaps under that level. On the next slide then, and really a sort of potentially very significant change going forward are some of the changes to exclusions. So broadly speaking, you'll remember mandatory exclusions and discretionary exclusions, those where the contracting authority had to exclude bidders if they ticked any of those bad boxes, and those where they may do so at their discretion. Those remain very similar to what they were before. They're now called excluded instead of mandatory and excludable instead of discretionary. What has changed, there are some new additional grounds for improper behaviour, and there are extended grounds relating to past performance. So it used to be that there was a discretionary ground, a supplier could be kicked out of the process if a previous contract that they'd been doing had been terminated for default. That's still there, but there is also now an ability to exclude a supplier where the supplier just has not satisfied the requirement. The contracting authority just wasn't happy with prior performance, regardless of whether that resulted in termination damages or anything else. So there is more scope now for a contracting authority to say, we just don't want you bidding for this contract because we didn't like the way you did the last one. So that's something potentially to watch out for. There's also this new central debarment list, which is a really significant innovation. So where a contracting authority decides to exclude a supplier for any reason, it is going to have to give notice to the UK or Welsh or Northern Irish government, depending on who has jurisdiction. And then that government has the ability, not the duty, but the ability to investigate whether they were right to do so, including compelling information from suppliers from the contracting authority. And if that government, that they will then prepare a report that will go to the UK government, and the UK government can decide based on that exclusion for that specific procurement whether or not that suggests that the supplier should be excluded from all procurements up and down the country. So anytime a supplier is excluded going forward from a competition, there is now this additional risk that it won't just be that competition where it starts and stops. There will be other competitions potentially across the UK where they will be excluded. There is a right to appeal, obviously being included on this, or indeed to later on seek removal from the list if the things that led to a supplier going on the list have changed. But those are quite limited rights. The debarment list itself is a public register, so being on that list will be a matter of public record. Any supplier that finds themselves on that list, it will be open to any potential buyer, public or private, and to your competitors to see that a supplier is on that list. And whereas normally, if you find yourself in a position of potentially being excluded, you can go to the contracting authority and say, you shouldn't exclude us. We've fixed the problem. We sacked the bad guy, we've put new processes in place, we've trained our employees better, we're better now, you don't have to exclude us. If a supplier is on the debarment list, they cannot persuade an individual contracting authority to let them, quote unquote, self-cleanse for a given procurement. The only way to get off that list is to go to the UK government and get off the list. It's not enough to go on a case-by-case basis. So potentially a really significant change there for suppliers that find themselves in excluded positions. And with that, I will hand back to Charles on direct awards.
Direct awards, I'm sure you'll all be aware of how direct awards worked under the old regime. Broadly speaking, if there was a circumstance in which an authority could make a direct award of a contract, meaning not going through any of the competitive procedures, if those circumstances existed, that existed under the old regime, are present now, then they'll generally be permitted under the Act as well. So a direct award can be made as long as the supplier isn't excluded, although there's a possibility for an overriding public interest to allow a direct award even if the supplier is excluded. So if it's basically the only place from which you can get something that is really required. The authority has to consider whether the supplier is excludable, as Jamie just explained, and there has to be a direct award justification available. And they're in Schedule 5 of the Act. They're substantially very similar to the old grounds for permitting a direct award. In terms of those existing grounds, one of them that's been tweaked, so the provision of extra goods, services, or works under a contract, under an existing contract, where the original tender documents or notice identify the possibility. It used to be that the contract had to be awarded within the last 3 years. It's now 5 years, so there's a longer look back window. The new ground for a direct award is to protect life or protect public order or safety. I like to call this the Matt Hancock rule, because you'll recall that during COVID, Matt Hancock, well, he ended up the face of this, but the government ended up in a bit of difficulty because it was issuing direct awards for urgently required kit and PPE and machines and that sort of thing without really following any of the procurement procedures or the available direct award grounds. They were just cracking on and doing it. And that was found to be unlawful. And I mean, it was unlawful because there wasn't a direct award ground available. There is now under the Act. One key change is that a transparency notice, and this is a notice that includes, you can see the information in the sub-bullet, that has to be published before an authority makes a direct award, unless it's relying on those Matt Hancock grounds. And that's a big change. So right now, if we're advising an authority on whether they can make a direct award, depending on how the authority conducts its business, one of the things we might advise them on is, well, you don't necessarily have the best legal grounds for making this direct award, but you might consider whether anybody will actually challenge it, and is anybody likely to challenge it if they never know what happened? This transparency regime now means that direct awards get publicized. So if you are discussing a direct award with a public authority, you should be conscious that there will be a notice about it that your competitors might see and they might decide to challenge that. And likewise, you might keep an eye on the register where these notices appear. And it might be that there are contracts that have been awarded by authorities to one of your competitors that you think, well, actually, I don't think the ground that they're relying on here applies. For example, they're saying, and this is something we've advised a client on recently, an authority is saying that only one provider can provide what they require. But then a competitor looks at it and says, well, we could have done everything on that list. We could have done everything the authority required. So that's something worth keeping an eye on for these transparency notices, because they'll specify information about the contract, its value, the supplier, the reason for the direct award, and the estimated date it'll be entered into. Now, there isn't a specified time lapse from publishing the notice and making the direct award. It just says the legislation just says before. So we'll see how that ends up being dealt with in practice. Just one point on direct awards. If a direct award comes out of a procurement that was covered by the public contracts regulations, then that will still be covered by the PCR. So, for example, if the basis for a direct award is that a tender was run and no suitable tenders were received then that justifies a direct award. So if that procurement exercise, that failed procurement exercise was under the PCRs, then the direct award can be made under the PCRs. So no transparency notice being the big difference there. So moving on to contract modifications, another area where we are frequently asked by construction sector clients for advice. So there are rules in the old regime that I'm sure many of you will have dealt with that allow contracts to be modified without a new procurement process in certain circumstances. The Act follows along with that structure, so a modification can be made without it qualifying as without it requiring a new procurement, and therefore without it being a direct award in the absence of a procurement. If you're within one of the permitted modification grounds, they're in Schedule 8 of the Act, or it's not substantial modification, or it's a below threshold modification. And those map pretty closely onto the existing contract variation grounds, substantially very similar, but we do have some additional clarity. So it now expressly says if you could have direct awarded the contract under the rules we've just discussed, then you can vary a contract that would make it into the thing that you could have direct awarded. You might think that's obvious. The regulations didn't allow for that. A lot of the grounds were similar, but they were never really worded the same, so you never knew if there was a direct overlay between the two regimes. The Act says there is. There's a new ground where a contract is varied to take effect of a known risk, which is it's a slightly odd concept. So it's a risk that could jeopardize performance but could not be addressed in the contract and was identified in the relevant notice as a risk that may result in modification. So the authority has to have known that there was a risk and known that it might arise, but not necessarily have been able to anticipate how it might arise or how the contract might need to be changed in response to it. Seems like a very narrow set of circumstances, but we'll see how that one develops. The length of a contract, we now have clarity on that. There were never any sort of hard parameters under the old regime for that. But the Act now specifies that a modification will not be substantial and therefore it will be permitted if the term of the contract is increased or decreased by up to 10% of its original maximum. In value terms, we always had a value provision. A 10% value change for goods and services or 15% value change for works in either direction will be permitted as long as the aggregate of all those modifications are below the monetary threshold and there isn't otherwise any material change to the scope of the contract. So that's not too different from what was there already. I just want to say a quick word on contract modifications, which this is not a point that comes up because of the Act, but it's a point that we see coming up a lot in relation to procurement and construction, and that's the use of or reliance on compensation event clauses or variation clauses, whatever term you would use for them. One thing that we often have to remind authorities and construction sector clients of alike is that the presence of a compensation event clause and the like in a contract does not give a legal basis for modifying the contract in and of itself. What that clause does is kind of say, if the contract is going to be modified, then here's a mechanism for doing it, and here's how you work out the effect on price. But that is not that doesn't qualify as a change that's provided for in the initial documents, because variations are only permitted in terms of the original documents, where the documents are very clear on what it is that might change, in what circumstances, what the contract will look like afterwards. So very much a sort of, you need to have an if X, then Y kind of clarity. So it's not sufficient for a contract just to have within it a mechanism for how the parties behave if there's a change. That is not itself grounds to justify a change. So any change still needs to be justified through one of the permitted modification grounds, even if the effect of that change is then worked out through your compensation event or variation clause. So hopefully that's clear, but let's take a question in if not. Further on contract modifications, like with direct awards, one of the main changes is in relation to transparency. So you have what's called a contract change notice, And again, this has to be published before making the modifications. No specified time lag, but we'll see what practice ends up being. Not if it's a non-substantial or below threshold change, although even then there's a caveat to that, which I won't get into. If you find yourself in that situation, I'm sure an authority will tell you, and if you need help navigating it, you can come to us at that point. But it would take probably 10 minutes to explain how the different caveats relate to each other. The contract change notice is quite similar to the transparency notice. They're identifying the contract, identifying the supplier, identifying the grounds on which the contract is being changed, that sort of thing. There's no obligation to provide a standstill period before making the change, but if the authority decides to allow a standstill period, then they have to allow a period of at least 8 working days, which, as you'll see when we come back to litigation, when I hand back to Jamie, that's the new sort of general standstill period. So not a mandatory standstill period, but if they're going to have one, it has to be at least 8 working days. And then the publication has to be of either the contract itself as varied or just the modification. In the event that the contract's value, either its original value or its value as modified, exceeds 5 million, and that connects to a transparency point you'll see on the next slide. Just the final point to note, if contracts were entered into prior to the Act coming into force, then any modification of those contracts are still covered by the old regime. And again, not massive difference in the grounds on which changes are permitted, but if it's under the old regime, you avoid the need for this contract change notice. But I just wanted to spend some time focusing on this, because again, like direct awards, this is in that category of things where we advise authorities and contractors, but the risk is primarily on authorities. And again, often the advice will be, well, you maybe have an okay chance of persuading a court that the grounds for variation existed, but is this ever going to get before a court when there isn't, by definition, under the old regime, there wasn't publicity around a contract being varied. Now there is that publicity around a contract being varied, which makes me think that makes me expect that public authorities will be much more reticent to just agree to vary contracts, or indeed to make direct awards, now that they know there's going to be that publicity, because it really changes the risk calculus for them. And just to reiterate, if a direct award is made or if a contract is varied out with the rules, then what you're in is essentially an unlawful direct award situation, and that exposes the authority to various risks, damages, but most importantly, an ineffectiveness order or a set-aside order, which Jamie will come back to. That's also a risk to the contractor, but is primarily an authority-side risk. So I think these changes will have quite a chilling effect on authorities' willingness to kind of go, it's a pejorative term, but off the books in varying contracts or direct awarding contracts in order to get what they want. I think the transparency requirements will be a strong incentive to do things very much by the book. So I mentioned other transparency measures, and there's a lot of transparency in the Act, a lot of increased transparency. Your tender notice, that's the notice that kicks everything off, not too different from before. The pipeline notice, this is akin to something that already applies to Scottish public authorities, but bigger buyers that have estimated spend over a certain amount must publish a list of all their planned £2 million plus procurements in the coming financial year. There's now a need for a procurement termination notice if an authority doesn't go through with a procurement. That's new. There needs to be a contract details notice. This is new and important and might actually be a little bit troubling for some bidders. When the contract is entered into, notice has to be published that sets out the supplier details, details of any options and renewals under the contract, and what KPIs are included in relation to it. And if the contract value is more than 5 million, the entire contract has to be published, which is not popular among bidders. There is the guidance provides for the possibility of redactions. The legislation doesn't. So there might be somebody might challenge this, and somebody's contract might end up getting published in an unredacted form, unfortunately. But there is at least guidance on redaction. So authorities should be open to redacting, even if ultimately that might end up being challenged. But that's something I'd be particularly interested in if anybody's got to the stage of entering into a contract governed by the 2023 Act. If you're having that exchange in relation to what the contract should contain, I'd be very interested to hear any war stories in relation to that. Contract performance notices have to be published. So if a contract includes KPIs and those have to, sorry, if a contract has to include KPIs, and that's the case for contracts £5 million plus, the authority has to report annually on the contractor's performance against those KPIs. So again, that increased publicity means that you should really be paying a lot more attention than you might otherwise have to what's going into your KPIs. There's then a requirement for a contract termination notice stating that any given contract is terminated and the reasons for that. And that includes that the contract has just run its course and reached its natural expiry. But it will also include details of any breach or failure to perform, as well as any damages or settlement figures, not just the fact of damages or settlement, but the actual figure awarded in damages or agreed by way of settlement. I could see David raising an eyebrow on that one. That's a real sort of difference in transparency and something that will need to be kept in mind and might actually discourage amicable resolutions where there are disputes, because publicity is never popular. And then lastly, the payments compliance notice. So this isn't about particular contracts, but public authorities have to publish annual notices saying how many invoices they paid within 30 days, within 31 to 61, or on or after day 61. So basically, as a bidder, you'll get a sense from these notices of how good a payer a given authority is, and might allow you to price accordingly or just decide whether or not you want to go for a particular contract. Moving on again, another point that will be of particular interest to construction, particularly given the use of subcontracts and things like that, is that the Act implies a number of terms into contracts. So in any public contract or a regulated below threshold contract, which Jamie mentioned, the authority is subject to a term that has to accept and process electronic invoices, pay any undisputed valid invoice within 30 days, or if the payment due date is later, they can pay on the due date. They have to notify any dispute or alleged invalidity without undue delay, and they can only rely on payment to a third party with the agreement of the payee. So that may weight contracts in favour of contractors in terms of payment processes and that sort of thing, more than they were previously. What you should be particularly aware of is if you enter into a subcontract that is substantially for the purpose of performing or contributing to the performance of all or any part of a public contract, then your subcontract will have implied into it the second to fourth terms about paying valid invoices within 30 days, notifying any dispute without undue delay, etc. And you can't contract out of those. So you can't contract out of those for your subcontract, and the authority can't contract out of them for the main contract. There is also an implied right for the authority to terminate if a termination ground applies, and that means if they discover that a contract was awarded or modified in breach of the Act, then they are able to terminate to get out of that situation. And likewise, if they discover that a supplier or indeed a key subcontractor has become, since the contract was entered into, an excluded or excludable supplier. So if you are found guilty of a bribery offence, then all of your public contracts might be at risk. And indeed, should note that one of the grounds for exclusion that's been moved into mandatory rather than discretionary is if you breach competition law. So again, that's something that Jamie and I do. So I just want to mention that specifically because if construction sector wasn't already enough in the crosshairs for competition law purposes, the relevance of that to procurement has been heightened under the Act. So if public contracts are a big part of your work, you need to be extra specially careful with your competition compliance. And with that, I will hand over to Jamie.
Thanks, Charles. So just a couple of words on litigation then. I'm not going to spend too long on this. We'll make sure we've left enough time for questions. But as Charles mentions, the old standstill period that was 10 calendar days is now 8 working days. Most of the time, that's not going to make a huge amount of difference, but it does potentially stop contracting authorities gaming the existence of public holidays and such as much as perhaps they used to, he says cynically. The key point really on that otherwise is that the beginning of a standstill period does not begin when you get your standstill letter or what is now called an assessment summary. So you'll get your marks from the contracting authority to tell you how you scored and whether you've won the contract or not. But that is not what kicks off the standstill period that you have to raise any challenge that you want to raise. What kicks off that is the publication of a contract award notice on the find a tender service. So that might happen. It has to happen after you get your assessment summary. It can't happen before. It could happen 20 minutes after you get your assessment summary. It could happen a week and a half later. It could happen longer than that. But just be aware that that is what kicks off the time limit for you to raise issues in court with the procurement. Duties under the Act are enforceable. So, for example, the duty to have regards to the procurement objectives, the equal treatment duty, the duty to have regard to the National Procurement Policy Statement, etc. So you can bring actions against a procurement, against a contracting authority based on breach of those. One thing excluded from that is the regulations relating to those below threshold regulated contracts that I mentioned earlier. Those rights are not enforceable. There are still duties. There are still potentially a judicial review of a failure to comply with those, but there's not a right under the Act. Litigation has to be in the High Court, Court Session, or Northern Irish High Court, depending on where you are. And the Good Law Project is just the case that says you can judicially review something even if you don't have a right under the legislation, freestanding. Really key point: automatic suspension. Typically, if you lost, you would write to a contracting authority and say, "Not happy with this. I think you've not followed the rules properly. Let's extend the standstill while we figure out whether or not you've complied with your obligations, Mr. Contracting Authority, or not." If there is no obligation on the contracting authority to award the contract at the end of the standstill period. However, the key change is this: the right to have the automatic suspension that says that the authority cannot enter into the contract if a legal challenge has been raised now only applies if the challenge is raised during the standstill period. It doesn't apply if it's raised at the end of the standstill period, even if the contracting authority hasn't yet entered into the contract. So if you've got an 8 working day standstill period, you get to the end of that, it's passed, contracting authority still hasn't entered into the contract, and you raise legal proceedings then, you do not get your automatic suspension. The contracting authority can say, well, thanks, that's great, interesting stuff, but we're still going to go ahead and award the contract to the winning bidder because you didn't raise your action during the standstill period. Now, a new contract award notice can potentially create a new standstill period, but putting that aside, what this is going to mean is a need to move much faster if you do think you want to raise a legal challenge to a procurement. Obviously, from the flip side, if you're the winner, what it means is that you're going to be protected against that potential delay much sooner than you were before, because there won't be as many just informal rolling extensions to standstill. And the general rule that once the contract is awarded, the court won't unwind it unless particular circumstances apply. That's still the case. So by and large, the remedies, if you raise an action after standstill, are really limited to damages in most circumstances. The next slide really just summarizes the distinctions between the old regulations, which are continuing in Scotland, and the new Act, but that's really just the points that I've made just there. And then there is on the next slide, a new potential option for you if you have a problem with a procurement, but you don't want to raise court proceedings to challenge that, there is now this procurement review unit within the Cabinet Office, albeit the Cabinet Office is shedding jobs, so who knows where it's going. But the procurement review unit is there and available to you if you want to raise issues with procurements by public authorities but you don't want to sue them. So the Public Procurement Review Service is there to investigate supplier complaints about specific procurements and issue effectively non-binding recommendations, but it is an opportunity to vent issues and get them aired. The Procurement Compliance Service is there to investigate systemic issues, institutional non-compliance. If there's an authority that's just never putting stuff out to tender or keeps awarding stuff to their favourite bidder, then that might be the person to talk to about that. And indeed, as I've mentioned, debarment, there is a debarment review service, and their job is to maintain that central list, and they're the people to talk to if you unfortunately find yourself on it and want to come off it. So I'll let Charles summarise the key takeaways from today.
Thanks, Jamie. So yeah, the Act's going to change, make quite a lot of change to how public bodies across the UK buy things, with the exception of devolved Scottish authorities. There's an entire webinar on how you decide who falls into what category, but ultimately, if you're a contractor, you'll be told which regime you're acting under. The Act gives some more flexibility, but significantly more transparency. So I would say it's added a lot more transparency than it has flexibility, but particularly in relation to contract terms, supplier performance, direct awards, and modifications, which really were why we focused on those things. A lot of established principles will be relitigated. Sometimes because the rules have actually changed, and sometimes just because the language has changed, and eventually somebody will commence litigation to see if the new term does actually mean the same as the old term, or means or if different words mean a different outcome. As Jamie said, if you're unhappy, you'll need to move even quicker than before if bringing procurement challenges. And even if you don't want to bring a challenge, your leverage only exists while you have that ability. So you're only going to have leverage for maybe 6 of those 8 working days. So if you get something that you're unhappy with, you need to act immediately. And another point, just to plant, remember that you still have the same sort of 30 working day time bar. If you have an issue with procurement, the initial procurement documents, you can't wait till the end, find out whether you've won, and then challenge the procurement documents. Your 30 days run from when you receive the documents, basically. So the message in procurement litigation is always act as fast as you can. Scottish courts will see 2 types of procurement litigation, so we'll look forward to managing that. And the procurement review unit is there as an option short of litigation and possible leverage against the public authority if they've done something that you're unhappy with. Even if you can't plausibly threaten litigation, you might say, well, I'm not happy with this and I'm going to take it to the procurement review unit and just see if that shakes something loose. So that's us, David.
Thank you very much, gents. We are almost out of time, but I think we've probably got time for one question. We've got a few through here, but I'm going to raise this one because it's been raised by a couple of people, so it's obviously hit a bit of a nerve. You talked about contractors being excluded from contracts based on unsatisfactory performance. What checks are there on the public authority in that regard? We've got 2 questions. Do you have to prove non-performance or unsatisfactory performance on past contracts? And what's to stop authorities abusing or threatening exclusion for unsatisfactory performance to leverage contractors in, for example, a current final account negotiation?
Yeah, I'll take that one if that's okay,
Sure.
Jamie. I was thinking about it while you were talking. It's not the case that the contractor can simply come along later and say, I don't like how you carried out that past contract, so you're excluded. So the supplier has to have not performed the relevant contract, I'm just reading here, to the regulated authority's satisfaction. But in addition to that, the supplier has to have been given proper opportunity to improve performance and failed to do so. So if you weren't told during the operation of the contract that they weren't happy with you, they can't tell you after the event that it turns out they were happy with you, even if they didn't say so at the time. So if it comes to sort of settling up at the end of a contract or coming to the next contract down the road, We were obviously the slides, it was a sort of a shorthand version, but there does need to have been that opportunity to cure the problem given during the operation of the contract, and the supplier needs to have failed to cure it before the ground becomes available.
Okay. Thank you very much. I think that's our time probably up. Certainly, as a construction lawyer, that has given me huge number of things to think about. I'm sure it's the same for our clients within the construction sector. Um, the part about implying payment terms into main contracts and subcontracts sends shivers down my spine on the basis that at the moment we see a huge number of disputes in the industry because we already have legislation implying payment terms, and now we
Mhm.
seem to have another set of implied terms for public contracts. So I'm not enjoying looking at that going forward. Thank you very much, gents, for the session today. But other than that, thank you very much, and thank you all for attending, and thanks to our speakers again.
Thank you.